I am now going to welcome Ms. Christina Sandefur, Dr. Joshua Comden, and Dr. Emily Hamilton. Welcome to the Senate State Affairs Committee. Ms. Sandefur, I hope I'm pronouncing your name correctly. If not, please do correct me. Please state your name, any organization you represent, and proceed. You'll have 3 minutes.
Thank you, Madam Chair, and members of the committee for allowing me to testify today. You did pronounce my name correctly, and you are one of the who do, so thank you for that. My name is Christina Sandefur. I'm an attorney and the Executive Vice President of the Goldwater Institute. We're an Arizona-based public policy research and litigation organization, and I'm testifying in favor of the bill. In my 12 years at the Goldwater Institute, I've negotiated claims under Arizona's version of the Property Ownership Fairness Act, and I've also co-authored a study that really looks into how Arizona's law has functioned in the 16 years that it's been on the books. There's been a lot of talk today in the testimony about balance. And the truth is, existing law just doesn't require balance. It also doesn't really protect due process. People buy property with rules and, therefore expectations in place. And when those rules change in a way that doesn't protect public health and safety, it takes away their right to use their property, their right to improve their property or develop it or sell it. And currently, under existing law, they're usually out of luck. So the Property Ownership Fairness Act is needed, really to fix existing law, because existing law makes it impossible for local governments to understand the true costs of regulation. Now, there's been a lot of concern about the costs of compensation, but the fact of the matter is regulation always comes at a cost to someone. And all the Property Ownership Fairness Act does is ensure that those costs aren't borne by the property owner alone. But if, in fact, these regulations are desired by the community as a whole, and they're not necessary to protect public health and safety, well, then the community as a whole should bear the costs of those regulations, since the property owner purchased the property without having any belief or expectation that those regulations and that taking of their property rights would come into play. So the Property Ownership Fairness Act addresses this in a fair, balanced way. It only requires government to pay owners when the regulations reduce their property values without actually ensuring public health and safety. And to be clear, nothing in the Property Ownership Fairness Act prevents cities from regulating to protect public health. And in fact, nothing prevents them from regulating at all. It just requires balance, the very balance that's been discussed throughout this testimony. Government pays if it takes away rights without protecting health and safety. The law was designed not to get people into court, but to facilitate negotiation, with litigation really as a true last resort. And in my experience in Arizona with this law, I have seen very, very, very few cases or claims go to litigation. It just allows for a dialogue between cities and property owners. Those claims are usually resolved outside of court, sometimes without any money exchanging hands at all. So it's been very effective in Arizona. I also have some experience with the law in Oregon, and I'd be happy to tell the committee about how that differs from the law that's being considered today if that comes up in the Q&A. And thank you so much, Madam Chair and committee, for your time today.
Perfect timing. Thank you. I will have a couple of questions when we get to that point, but I'm going to shift now to Dr. Joshua Comden.
Hello, my name is Joshua Comden, and I represent myself and my family. I live here in Lakewood, Colorado, and I moved here about 2 years ago because I am now working in the renewable energy industry. I recently got my PhD 2 years ago before coming here in applied math to work in the renewable energy industry. And I got myself a fairly nice apartment in Lakewood, but rents keep increasing. And I realized that a couple months before I moved here, Lakewood had passed this strategic growth initiative or something to limit how much can be built here. And I started paying attention to local politics and seeing what's going on here. And actually, near my apartment complex, there was a proposal to build another apartment complex. And that ended up getting scuttled because people thought, oh, there's too many apartment complexes in this area or something like that. But then in other places in the city where it's all single family homes, they use this strategic growth initiative to stop other growth or anything else to be built. And so we see rents increasing. So I thought, okay, you know, I'm a young professional. Maybe I should go out and look in the housing market. So 2 or 3 weeks ago, over Martin Luther King Jr. weekend, my wife and I, we went gallivanting around Lakewood to see what we could afford. And lo and behold, there's really not much I can afford. There's like this 2-bedroom, completely gutted home that looks like it hasn't been occupied for 10 years. Apparently that's what I can afford. And so I realized that I shouldn't have gotten a PhD in applied math and gone into the renewable energy industry. I should have, I don't know, gone into construction so that I could actually own a home one day. And this is just, I don't know. It just seems like the current property owners of this community do not want undesirable people like myself there. Thank you.
Thank you, sir, for sharing your experience. And I would disagree and say that we're very appreciative of the work that you do and your participation in community and your participation in this community. I will now shift over to Dr. Emily Hamilton.
Thank you, Madam Chair and members of the committee. I'm Emily Hamilton, a senior research fellow at the Mercatus Center at George Mason University. I'll make 3 points today. First, local zoning restrictions cause housing affordability problems. Second, local policymakers face incentives to implement policies that restrict housing supply and drive up costs. And third, the Property Ownership Fairness Act would increase opportunities for more housing at lower prices. To my first point on zoning and affordability, in Grand Junction, where I grew up, house prices have increased 57% after adjusting for inflation over the past 20 years. Rising house prices are not an inevitable consequence of population growth. It's only within recent decades, as local zoning rules have become more burdensome, that house prices have consistently risen faster than construction costs. To my second point on local policymakers' incentives to limit housing construction, the costs of new housing construction are local. They often fall on people who live directly next to a new development. But the benefits are widespread, primarily going to people who will live in the new homes. They may not even be residents of the locality where the new housing will be built at the time that it's proposed. As a result, local policymakers regularly pass rules that chip away at property owners' rights to build new housing. And to my third point on protecting the right to build housing, development rights and housing affordability go hand in hand. This bill would require local policymakers to weigh the benefits of new land use restrictions against the fiscal costs of implementing them, rather than considering the benefits of new zoning restrictions in isolation. Others have raised the concern that this law would prevent localities from implementing inclusionary zoning rules. I've studied inclusionary zoning in the Baltimore-Washington region, and what I found is that localities with inclusionary zoning policies have higher house prices than they could have expected without those policies. Nonetheless, local policymakers who want to implement inclusionary zoning without having to compensate property owners for doing so under this bill could do so by including density bonuses large enough to prevent their inclusionary zoning ordinance from reducing property values. This bill would make housing in Colorado more affordable than it would be without this increased protection for development rights. Thank you, and I'm happy to answer any questions.
Thank you all so very much for your testimonies. Colleagues, questions for this panel of witnesses? We'll go with Leader Holbert, and then I have a couple as well. Proceed.
Thank you, Madam Chair. A question, since we have multiple guests with us, for Ms. Hamilton and Ms. Sandefur, how has Arizona's Property Ownership Fairness Act worked in practice? And then I believe Ms. Sandefur, being with the Goldwater Institute, I assume you are in Arizona. Could you comment about the practical implications of the bill and how it might work here if it becomes law in Colorado? Thank you.
Yes, Madam Chair, Senator, the bill in Arizona, the law in Arizona has, again, been on the books for 16 years. We track it very carefully. I've been involved in a lot of claims that have been filed under the law. Again, very few ever make it to court. Very few are needed to go to court. But how it functions is, again, it really has required local governments to internalize the cost of regulations, to think about the cost of regulations, to learn what those costs are to individuals' property rights, and then to think about whether, in fact, those regulations are worth the cost. If I may, I'd like to provide a quick example that I think really illustrates how this law has functioned in Arizona. So shortly after the law passed, Luke Air Force Base, which is located in Maricopa County, the largest county in Arizona and where Phoenix is, worked with the county to put restrictions into place because there was a concern about how housing developments and growth in the area might affect the Air Force Base. Now, rather than think about what regulations were actually necessary to protect the Air Force Base and public health and safety, instead, since there was no understanding of what the cost would be, the county simply just put a building permit moratorium into place for that entire area. That means that no new houses could be built on empty lots. So people who had purchased empty lots saw the value decrease to about 95% overnight. It meant that people couldn't make improvements on their houses, including necessary electrical improvements that were actually safety concerns. And it meant that people couldn't add things onto their homes. A veteran in the area actually wanted to install a therapeutic spa that his doctor had recommended and, again, wasn't able to because of that regulation. So my organization, the Goldwater Institute, was actually contacted by local property owners who were deeply concerned about how this had taken away their property rights and reduced their property values after they had purchased this property with different expectations. And we filed claims on their behalf with Maricopa County. And the claim values were totaled around $20 million. Now, we didn't file a lawsuit. We didn't have to go to court. We simply sent a letter, which, by the way, doesn't require a lawyer. Any property owner could send their own letter, simply letting the county know that millions and millions and millions of dollars had been reduced from these property values. And the county took that into consideration. They hadn't really realized that and were only kind of thinking about one side of the regulation. And the county went back and looked at that ordinance and basically asked itself the question, is this severe, strict regulation worth the tens of millions of dollars that we'll have to pay out in compensation? And again, the answer was yes, the county could have paid that money in compensation, or it could have gone to court, or worked with the property owners to come with some kind of negotiation. Instead, what the county said is, you know what, we don't really need this ordinance to protect the Air Force Base. We can rescind it and pass something that is much less restrictive and really uses a precision tool to address what's actually needed. And that's what the county did. Didn't have to pay a dime. Property rights were restored, and the Air Force Base was still protected. That has been my decade and a half experience with the Property Ownership Fairness Act in Arizona, and that is really the magic of this law.
To add just one additional example, in Tucson, near the University of Arizona, there was a neighborhood where property owners were building multifamily housing to serve primarily that student population. Residents living near the area where the multifamily housing was being built proposed a new ordinance for the neighborhood that would have prevented the construction of this relatively low-cost housing. And as Christina discussed in the Maricopa County case, Similarly, the proposal was not something local policymakers chose to go forward with after it became clear that it would require compensation for the property owners who would have lost their right to build that multifamily housing.
Just for the record, that was Ms. Sandefur and then followed by Dr. Hamilton in the responses. Thank you, Senator Holbert, for that question. You had a second question as well.
Yes, Madam Chair. I'm curious, any of the panelists, I don't understand the term downzoning. Could you help me understand what that means?
Who would like to respond to that?
If anyone can.
Senator, I'm happy to respond.
Dr. Hamilton.
Thank you, Madam Chair. Downzoning is a term used to refer to any regulation that takes away a property owner's development right. So, for example, if a property is currently zoned for multifamily housing and a locality were to pass a new rule limiting development to exclusively single-family housing, that would be an example of a downzoning.
Thank you for that response. Senator Simpson.
Thank you, Madam Chair. Excuse me, a frog in my throat. For Ms. Sandefur, you teed it up, so I'm interested your perspectives and observations about the law in Oregon. You kind of hit that topic, so interested to hear you elaborate on that.
I too am interested in that, particularly because politically Arizona and Oregon are like wildly different places. And so, just a little bit. And so I'm curious for the perspectives on how the law has played out in Oregon, and to build on Senator Simpson's question, how this proposal would be different, Senate Bill 63. Thank you.
Yes, thank you, Madam Chair and Senator Simpson. I will say that Arizona and Oregon are perhaps less politically difficult these days than they were in the past. But, with regard to the law in Oregon, I agree that law was not crafted in a smart way. And what made that law such a disaster for the state is it was retroactive. So it allowed property owners to bring lawsuits over regulations that were passed before the law enacted, over regulations that were in existence when an owner took possession of the property. And so, as you can imagine, it was mentioned earlier how there was an influx of litigation. Well, of course there was. People, were sitting on their property with regulations that were already in place, and suddenly a law comes on the books and says, hey, you can go into court and get compensation for laws that were already in existence that predated this law. And so people jumped at the opportunity to do that. Now, some of those claims, I'm sure we could be sympathetic to, others maybe not. But the fact of the matter is that's not what fairness is about. That law wasn't called the Property Ownership Fairness Act. The fairness concept that exists in the Arizona law and that exists in Colorado's version, which is virtually identical to Arizona's, says just that when a property owner, when someone purchased property, there's a set of regulations, zoning, that sort of thing in place when they buy that property. If that changes in a way that takes away their right to use that property, that isn't necessary for health and safety, and that actually reduces their property value as a result, then and only then can they start this compensation discussion. And that's fair because, of course, as someone alluded to earlier, a property owner purchases property with certain expectations in place, including the state of the law as it stands. And so that's why compensation is allowed. And frankly, that's why you don't see that many cases in Arizona in court, and you saw many in Oregon, even though, one might argue that the folks in Arizona are even more protective of their property rights or concerned about their property rights than the folks in Oregon. And again, that's just because the law is not retroactive. The law was forward-looking. The law only applies to changes that happen after a property owner purchases their property. So I think an important lesson was learned in Oregon. I think it is smart that law, as it was written, is no longer on the books. And that type of result would not be possible under Arizona's law or the law that's been proposed in Colorado.
Senator Simpson.
One more question, and it's not a follow-up. And I don't know if it's appropriate for the panel or maybe the bill sponsor later, but there's panelists that have some expertise. I'm interested in the federal nexus. Does like Clean Water Act or Waters of the U.S. or endangered species, critical habitat, what is the, if any, what's the federal nexus?
Who would like to respond to that?
Madam Chair, I can if you'd like.
Ms. Sandefur, please proceed.
Yes, Madam Chair, Senator Simpson, it's a great question, one that you can imagine was considered quite a bit in the state of Arizona, which, like Colorado, is under federal environmental jurisdiction and a great deal of our state. And there are actually several exceptions that are written in Arizona's law that also exist in the Colorado version of the bill that would say that compensation wouldn't be required where federal law governs. So first of all, there's the exception that explicitly says that a regulation that is imposed or required by federal law doesn't require compensation. And again, under the fairness concept, that makes sense. You can't expect cities or state government to compensate property owners for laws that they didn't even put into place. But there's also the exception that deals with protecting public health and safety. Those also don't require compensation. So for example, if I am polluting, that violates, that affects public health and safety. And if my state or local government passes a law to stop me from polluting my neighbors, that would not require compensation because, again, that's something that was necessary to protect the public health and safety. So those are two areas of the law that deal with your question about federal environmental regulations.
Excellent. Thank you so much for that information. That's very helpful. I guess just to clarify and put a finer point on it, is the only substantive difference between the Oregon policy and Senate Bill 63 that we are discussing today the retroactivity, or were there other aspects of the Oregon policy that differed?
Madam Chair, in my opinion, that is the main substantive difference. I don't have the law in front of me right now to look at the exact language, but it functioned pretty similarly to to the Arizona law or to the one that's been proposed. But again, I think that's a very significant difference.
Thank you. And given Colorado's statutes regarding retroactivity, I think, that would certainly be quite different here. All right. Any further questions for this panel? Just one final question that I have for you all. The language of the bill, I just want to see here. Give me just a moment, sorry, to pull this up. The definition of land use law that is proposed here in Senate Bill 63 at page 4, lines 13 through 18, would include both statutes that are promulgated by the local municipalities or governmental entities themselves. But I guess my question is, would it also include a ballot measure, like a citizen-initiated measure?
Madam Chair, I'm happy to answer that.
Thank you. Ms. Sandefur, please.
Yes, I believe that it would, typically, and again, depending on whether those are done at the local level or the state level, those would be codified then as statute or as an ordinance. That's in part why I think the language is so inclusive of many different terms, codes, rules, regulations, things like that, in order to be able to, essentially cover something that is enacted into law and is now, affecting the property rights and the property values. Now, of course, the bill could be amended to adjust that, but as written, I believe it would include that.
Thank you, Ms. Sandefur. And both the Arizona statute and the Oregon statute do contemplate, if I understand correctly, this takings statute. And I am curious, in the just compensation required when one of these anti-growth measures is enacted. I am curious how there was a prior conversation with opposition around what the nature of government, what the purpose of government should be in balancing the personal property interests with the public property interests. Is this the right balance? Do you all see, and I guess I'll start with Ms. Sandefur. Do you think that this bill strikes an appropriate balance?
Madam Chair, thank you. Yes, I do. The term just compensation comes from other areas of property law. It was eminent domain law was briefly mentioned earlier, of course. Eminent domain is a recognized function of government, but of course, when government takes away your property, it gives you just compensation when it does that. A taking by regulation in the narrow way that's described in this bill is also a taking of a property right. In fact, it's just more, under the current law, it's more insidious than eminent domain, because when eminent domain occurs, government takes your property, it gives you money in return and fairly compensates you. Under a regulation in this context, you don't expect a change. You purchase property, government takes away your right to do something with that property, and if it reduces your property value, you're still stuck with the mortgage on that property, the insurance on that property, the liability if someone's harmed on that property. The property is now worth less, so you aren't able to sell it for the same amount of money that you would be able to before. And yet government, under existing law, usually has to give you nothing in return for that taking. So this is just an equitable law that takes that principle that already exists in law and extends it to any time government takes away a property right, again, not in the furtherance of health and safety, which is something you don't have a right to in the first place. So I do think it strikes an important balance. And I also think it's important because it does not stop government from regulating. I mean, truly, we were talking about the limits of rights, and I'm sure many of us that are here today could disagree about where those limits are. But if we were really enforcing property rights to a T, we would say that government just could not regulate in this way. And that's not what this bill does. This bill just says that, look, if government's truly taking away a right, and it's going to do that, then it needs to pay for it. That's all. It doesn't say government can't regulate. So I do think that this is a fair balance. I think the existing law is not a fair balance. It's very unfairly skewed outside of the favor of the property owner, but also is frankly unfair to the people considering the regulations and to the community as a whole, because costs of the regulation are just unknown and unconsidered.
Seeing no further questions, I do want to thank you all for sharing your personal experience and your professional experiences across different states throughout the country in regards to this policy. Thanks for sharing your perspectives.